Welcome to Checkpoint. Today we're talking about what happened at the Assembly of State Parties that took place at The Hague. Did Kenya present a strong enough case? Did they discuss the issues that they should have in a legal manner? Was it political posturing? Also, the big question about the victims, does that get lost in our conversations? And finally, do you think the ICC still offers the best hope for justice for victims of Kenya's post-election violence? Please do get in touch with us on Twitter at KTN News, at John Alanamu, at Yvonne Okwara. Use the hashtag Checkpoint. You can use the SMS number 22155 if you prefer. It's absolutely free. We'd love to hear you. Engage with us on this topic of discussion tonight. I've got with me Dunstan Amari, who's an advocate. Thank you very much. Political analyst and also lecturer at Catholic University. Then we have Muthoni Wanyeki, who's the regional director for Amnesty International. We thank you for being with us. Let's just start by talking about the case that was presented at the ICC. Civil society was there, government was there, and all the members of the ICC. Muthoni, let's start with you. Did Kenya present the case the way it should have? Was it a big miscalculation? What do you think of how the country conducted herself at the ASB?
I think we should look at sort of the substance of their requests. And the first request had to do with Rule 68 and the retroactivity of its application. Our position has been, and we've made that position publicly available, that yes, that rule does require interpretation. However, the best place for interpretation, and in fact the only place for interpretation, is within the court itself. The matter is already before the court. It's before the appeals chamber. The defense has submitted on the matter. The African Union has submitted on the matter. So to try and engage what is essentially a political body on this question is completely out of order, especially when the option was there. The other substantive issue that they had put forward was this issue of wanting to interrogate the Office of the Prosecutor's conduct with respect to essentially how the OTP found witnesses.
Right.
Fair enough. Kenya has every right to ask questions about that. I think there are a lot of questions about witness tampering, witness coercion, witness bribery, etc., that we have consistently urged that be investigated. But what Kenya was putting forward was the creation of an ad hoc mechanism. And our position on that was, look, the statute provides already for an independent oversight mechanism. Yes, it's in the process of getting set up. But push for it to be set up. Why have another ad hoc mechanism? So I think Kenya's sort of intransigence around rational ways of dealing with the concerns that it had has really blocked it into a corner, because I think they went in expecting a lot more support, particularly from Africa, than actually they had. They've proven to have. So in a way, I think Kenya's going to end up with egg on its face.
All right, okay. And we'll talk about how much support Kenya really does have within Africa. Dunstan, what are your thoughts, on this? Did we go into a situation where we're presenting political arguments for what is essentially a legal case?
Well, Article 112 of the Rome Statute provides for that mechanism. The conduct of the prosecutor, the conduct of the judges is part of what is provided for in Article 112. So really what Kenya was doing is complying with what the provisions of the Rome Statute provide for. Kenya presented a very wonderful case. One, its agenda was put for that business. That is a big plus for the Kenyan country. Remember very well that the ICC has no time for Africans. It has only time for Africans in the name of civil society, but in terms of leadership of African, as much as it is, they have no time for that. The fact that that agenda found itself there was a plus on it. Two, the fact that that agenda was now referred to the Bureau is also another plus in this matter. Three, what we are seeing is that in the Bureau, what is actually being debated is the language, because it is consensus. There is no way you can apply a law retrospectively, backwards. In the statutes itself, Article 24 provides for, in the Rome Statute, that you cannot apply a law retrospectively. Article 50, and I read for it, Yvonne, Article 52 3 provides that in case the rules change and those rules of procedure change, the rules cannot apply to an ongoing matter. And that is for the benefit of Kenyans. It says after the adoption of the rules of procedure and evidence in urgent cases where the rules do not provide for a specific situation before the court, the judges may, then 4 goes, the rules of procedure and evidence, amendments thereto, and any provisional rule shall be consistent with this statute.
Okay.
Amendments, when they have been made, they cannot apply retrospectively.
All right, Dunstan, I think that seems to be a matter of perhaps agreement. All the way
Consensus,
around.
yes.
There is consensus on that. Perhaps what people question is how then to go about discussing that issue, especially when it's already before the court. Was the ASP the right place to have that discussion?
I would say not, actually. I
Yvonne,
think
what
the
I'll
whole
say-
concern
All right.
was that this was
Okay, we'll come
challenging the the independence of the court. That's the big
So
concern.
this was not the place
It
to
was
discuss the
before the court.
interpretation
It's
of Rule
before the
68?
appeals chamber.
Okay.
No one questions that Kenya has a right to raise that kind of substance. What they question is turning essentially a legal body into a political body.
Dunstan?
My position is that Article 1112 of the Rome Statute provides for that. In the wisdom of the framers of the Rome Statute, if they did not intend that such a motion can be brought before the Assembly of State Parties, they could have made it expressly clear. The fact that it is provided for in Article 1112, the oversight mechanisms makes it legal, and that is why it was allowed.
Okay.
If indeed it was an illegality, it couldn't be allowed.
All right, fair enough, if we're to take your argument. So let's run with that for a minute. So do you think then Kenya presented, a very strong case? They were given the floor. They were allowed to discuss the issue. I would like to reference George Kegora's article in the newspaper today, and he talked about the manner in which it was done. And if at some point we can have some of the quotes from Cabinet Secretary for Foreign Affairs, Amina Mohammed, that we perhaps went in, chest thumping, and immediately after the case was made, the Kenyan delegation then walks out. What does that say to the other members of the ASP whom you hope, to win over? We've come here, we've made our case. Some say to some degree it was, arrogance, perhaps a bit more ebullient that they should have been.
Well, Kegoro comes from the civil society. He will be seeing that from the lens of the civil society.
How do you see it?
In my own perspective is that it does not matter how you perceive the presentation of an argument. If you do not subscribe to that argument, you always see that argument to be arrogance. The Kenyan case was put very clearly, and the message was very clearly, and there was no mincing of words, that the ICC does not tolerate an African who is raising an issue with it. And
But
that
they
is
did
why
allow
our
the issue
ambassador,
to be discussed.
for the first
right?
time, because of that pressure, for the first time, the ICC has given the Africans a chance to air their views. And that is a position that we should be expecting our sisters, the civil society, to come on board and put that agenda across, that as Africans, we have a dignity. Whether you see us from a certain lens, we have a point to be heard. And that is the way it is. So I find it very, very, very unfair for my learned counsel, Kegoro, to say that it was a chest thumping. It wasn't a chest thumping. It was a way of putting the agenda through.
Okay.
And if the agenda was dismissed, it couldn't have gone to the
All right,
to the
but
bureau.
yes, but we have
There's
to
a
wait and see
difference
what the Bureau
between
says.
diplomatic pacification and really sort of taking an issue on. Like I said, the majority of states present made it very clear during their interventions they consider this to be potential interference with the court. But they wanted to pacify Kenya, so they gave them the room to speak. It's now been referred to the Bureau, but I'm sure the decision that will come out will have to do with protecting the independence of the court.
Let's talk about Africa for a moment and the support that Kenya hopes to get from African nations. Only Uganda spoke in favor of Kenya. And, a similar thing happened, if you think about it, at the last ASP, when Kenya was trying to make the case that heads of state should not be taken to The Hague. And even then, South Africa was the only one that came out, in support of this. Dunstan, do you think that Kenya has the support of the ICC? And I'll tell you why. Several countries have recently themselves referred their cases to the ICC. Uganda, Ivory Coast, Central African Republic, and Mali as well. So is it doublespeak when African countries are referring their own cases to the ICC, but at the same time saying the ICC does not listen to us?
What the Africans are saying is that per se the ICC court is not a bad court. It only needs to be reformed. It only needs to comply to universal principles of justice and the law. I'm a lawyer. Really, when you find that the ICC is going below the standard, the minimum threshold, I'll take you back. The question of a law applying retrospectively, that is a concept that was brought about by Lon Fuller. Lon Fuller, a jurist, came out very clear and established that for a law to be valid, it cannot apply backwards. Therefore, when the ICC goes wrong, it is upon the Africans to raise up their views. When you talk about Uganda as the only country that supported Kenya, was it strategy? Was it a way that there is silent diplomacy? The Kenyan government has lobbied very well. That might be our strategy. If only one country supported us, why was it referred to the Bureau? The Bureau is only going to tone the language so that what we are expecting to change is the semantics, and it's not really the gist of the matter. And my position is very clear that Kenya did a tremendous job because it has succeeded to push the agenda all through with...
Well, can you fairly say that you are successful until we hear the outcome of what the Bureau decides on Tuesday?
I think it's also... Can I intervene? I think it's also important to take correct readings of the diplomatic temperature. Mm-hmm. Kenya's sort of kicking and fussing and jumping up and down. Everyone wants to pacify it. Everyone does want a kind of consensual position, but that does not mean that they've taken on the substance of the arguments. And in terms of the question of African support, I think it is really instructive to look at who actually stood up around Kenya on this. West Africa was nowhere in sight. Botswana was nowhere in sight. This idea that there is a common position on every single little matter that Kenya wants to take forward is just simply not holding true.
All right. So for you, it doesn't necessarily hold true. Anyway, we'll see what happens on Tuesday.
Yes.
When the decision comes out on this one. I want to touch a little bit on the allegations about civil society because they were part of this. Dunstan, your thoughts on civil society, their presence there, and of course their statements and their position regarding the Kenyan cases. There's an article that will be coming out tomorrow by Ngunjiro Mbugu, who was there and is talking about civil society being funded by foreign powers. How can they purport to then speak on behalf of Kenyans?
Well, we look at the historical perspective and put this story to context. The civil society started to fight a political agenda way back when Jubilee nominated the president and the deputy president. They went to the Kenyan courts to stop them using Chapter 6. They failed. After the elections were done, the same civil society funded and tried to file a matter before the Supreme Court. They lost. They have now gone saying that witnesses have been killed. For example, when they say that the deputy president and his group murdered people like Yebei. Yebei was the defense witness. He wasn't a prosecution witness. Lastly, when you look at now, they've taken this agenda to the ASP, to the ICC. Are they fair? Who funds them? Whoever pays the piper decides what music to be played. We do not have the civil society in this country. Look, Article 10 of the Constitution talks about patriotism. Are the civil society patriotic to this country? Just because
I would actually ask whether so-called intellectuals, like our learned friend sitting next to us, are patriotic themselves. I would remind our learned friend who it was that first raised the questions of what patterns of violence had happened, what kind of victims had been affected, who've been pushing this whole time for the right of victims to full restorative justice as well as retributive justice. It is not correct to pretend that we have a criminal justice system, which people like our learned friend should support, and yet essentially what has happened with this case means that somebody who has murdered one person can get off, will face the law. Someone who has organized the murder of multiple people in the 4 different patterns of violence that happened in 2007, nothing will happen to them. This is not correct. In terms of the numbers of victims that we deal with, everyone sort of says, well, you know, reconciliation, reconciliation. This is true. This is something that is needed, but it can only come as a result of justice. Justice is not something that can be put to the side in the interest of sort of, well, calm down, you have no needs, etc. I think the attacks on civil society are extremely unfair, they're extremely disingenuous, and they're part of a kind of onslaught and propagandist kind of attack on civil society that's not true. Speaking for Amnesty, our money doesn't come from foreign powers. We are a membership-funded body. We have 7 million paying members all across the world, including in Africa, who support our work. So it's completely false to make it seem like, you know, just because, well, who are these foreign powers anyway, and what is their interest in destroying the government? What is civil society's interest in destroying the government? That is not our interest. Our interest has always been justice for the victims and justice in a deterrent sense. I think all of us who grew up in Kenya know the pain, the kind of destruction that's been caused by politically instigated violence. And I think that is why civil society is holding so strong to the line on the need for criminal justice in this case.
All right, Dunstan, when you talk about patriotism, do you think civil society, how would you define patriotism?
My definition of patriotism is one. We saw what happened in France when the bomb was hit. You didn't hear any of the France people start talking so bad about their country. As in this country, the civil society group have never at any one time been part of government. Because to them...
But civil society isn't supposed to be part of government.
What I'm saying,
is it?
They cannot see anything right that government does. It is that they've taken the role of the opposition. Let us look at my friend's argument that the victims need justice. Do you give justice to the victims by jailing an innocent person?
Is he innocent, though?
Has he been proved guilty?
But then we cannot say he's innocent.
And the question that we have, the way the law has been amended, the way Rule 68 comes in place is purely to justify the existence of the civil society and the ICC court, that they must produce a head. And one of the heads they have targeted to produce is the head of Sang or Ruto. So what we are saying is that let us not be blinded that we must get justice. The question that nobody wants to face is one: did Ocampo do proper investigation? If Ocampo failed to do proper investigation, you do not nail somebody who is innocent.
Okay.
The court should admit, and the civil society should admit, that the evidence they gathered, that evidence was procured.
All right, but then
civil society did not gather evidence for the ICC cases. Civil society documented the violence that happened, the patterns that emerged from what they documented, the groups of perpetrators on both sides, on 3 sides actually, because there were 4 patterns of violence. There was organized violence in the North Rift, there was equally organized violence in the South Rift, there was violence committed by the security services, and there was sexual and gender-based violence. That's what civil society did, was highlight and call, if you recall at the time, repeatedly for the demobilization and the use of mass violence in this kind of situation. It's just disingenuous to pretend that, you know, we had anything to do with once the referral happened.
So, Dunstan, in your view, how do we then start to get justice for the victims? Some put forth the argument that, yes, while we want to talk about the ICC not being a fair avenue, what have we done in Kenya? We have the International Crimes Division that was put in place, still, you know, setting up to sort of look after some of those cases that the ICC cannot, and this was done when we adopted the Rome Statute into our constitution. We talk about restorative justice, but where is that? And some say that even as we're mudslinging the ICC and saying they're not doing a good enough job, that we're not doing a good enough job, you know, in the country either.
That blame shouldn't go to 2 people. It's true we have failed as a nation to prosecute those ones who did those atrocities. But that does not make it that because the government or because the Kenyans have not done anything to bring restorative justice to individuals should carry that burden.
But Dunstan, with respect to my question,
yes,
what can we do locally? Let's put Sang and Ruto aside for just a moment, but have we done enough, and what do we need to do going forward?
We need to do a lot. We need everybody to come up and say, in the report of work, my sister says they documented. They know by name who raped so-and-so. The people know who stole their land. The people know who raped them. The people know who burned their houses. That should be the way to go now, so that we are saying, let us get a way to deal with this matter.
And how would you propose
the
we do
government
that?
has been not given chance. They are busy fighting the civil society in the
Okay. Hang on a second. So the government, in your view, has not been given the opportunity to do
Yes.
so. So what exactly is hindering them? If you can, just be a bit more
According to
specific.
him, civil society, when civil society has fought the hardest for justice. When the Waki report came out and recommended a special tribunal, it was civil society that, made proposals on the legislation, lobbied for the legislation to pass. It was Parliament that decided, no. Well, don't be vague, go to The Hague. Then they started talking about a special division of the High Court. Again, civil society engaged with that process, tried to get it going, nothing. Civil society tried to engage and sort of respond to the DPP's task force on the issue. I mean, in terms of who has been pushing for victims' voices to be heard and for this question of justice and accountability to take forward, it's certainly not been all the politicians who are trooping off to The Hague, and it's certainly not their propagandist crew of quasi-intellectuals.
Can we talk about the ICC for a moment? And with all the doubt that's been raised, and truthfully, no cases that we're seeing from other parts of the world. And many starting to say, look, if we're even getting to the point of questioning how the Office of the Prosecutor conducted itself in terms of collecting evidence and gathering that and speaking to that, and with all the political rhetoric that now surrounds this case and perhaps others in the conduct of the ICC, Muthoni, do you believe that the ICC is still the vehicle that will deliver justice to Kenya's victims, to Uganda's victims of what happened in the north, in the case of Laurel Gbagbo that is now before the ICC? Do you believe that the ICC now still has, that perception that it will deliver justice for the victims?
I mean, I think there are two sets of issues. One is sort of what is happening with institutions of the court themselves. And I think definitely since the entry into office of the new registrar and the entry into office of no longer new prosecutor, there have been real efforts to look at sort of how do you improve investigations, how do you deal with sort of the court rulings on sort of problems with the question of intermediaries' access to victims and potential witnesses. How do you deal with that? There are huge internal debates going on and huge steps that have been taken in terms of internal policy to fix this. And if people bothered to look at sort of the range of kind of reform initiatives that have also come from civil society, because we're not unquestioningly supportive of the court. We have put forward very strong criticism in many of the domains actually that the Kenyan government has put forward, but we have put forward it constructively with a view to the court as a whole, holistically moving forward. And you can research Amnesty's positions on all of these matters if you wanted. So I'm not saying the court is perfect, even within sort of the court itself as an institution. I think the bigger question really has to do with the nature of, or the tendency of political actors at all levels to instrumentalize any institution. And one of the most vexed questions obviously has to do with the tendency of global power to instrumentalize the ICC through the referral mechanism of this Security Council. Now there, the Global South, I think, has a common agenda, has for years on reform of the Security Council, and definitely has a policy or a sort of position on the need to reform that referral mechanism.
Okay.
So, I mean, no one is saying that there aren't problems, but please deal with the problems in a holistic sense moving forward.
All right, just quickly before I get to Dunstan in just a moment, the perceived bias, because many of the cases are African nations, 34.
Well, I'm sorry,
in terms
as
of the
long
membership
as
of
we are
that,
committing mass atrocities and as long as mass political violence happens on the continent, I personally, as an African, want that dealt with. If it's not going to be dealt with within our own domestic systems, then I want it dealt with at the African level. But the sort of granting of criminal jurisdiction to the African court is new. It's going to take years tons of resources for that to get going. So the ICC remains, in many cases, our only
venue. There's also mass atrocities in various parts of the world.
Sure,
Syria,
and that if you look at the range, of places where the ICC now has opened preliminary examination. Palestine, it's been going in Georgia for a long time. It's been working with Colombia for a long time. It is moving forward. And again, if you look at questions of strengthening the court, one of the things that Amnesty put forward was the question shouldn't be, let's have a 1, 2, 3, 1 per continent thing. The question is the court needs to be where the court needs to be, and it needs the resources to do that. And if you look at the budget of OTP and of the courts, that won't happen. And that's a whole other debate that's meant to happen at the ASP, unfortunately crowded out in the media coverage here by this very small agenda of Kenya's agenda items, rather than looking at strengthening the court moving forward to let it engage with all the situations that it needs to.
All right. Dunstan?
Yvonne, justice must not only be done, it must be seen to be done. 8 cases, ICC is dealing, all of them Africa. We have serious atrocities in Iraq, Palestine, Iran, Iraq. We're dealing with issues in all over the world.
To be fair, though, those cases
Ukraine.
were referred by the countries, at least a good number of them.
Because
so if we go to the ICC and say, we want you to handle these cases, well, fair enough.
We went to the ICC willingly because we thought that is a court that will follow universal principles, only to discover that it is even worse than the Milimani courts that we go every other day. So what we are saying is that, and she has agreed that the court there is need to reform that court. And if there is need to reform that court, the court needs only to admit and apologize that this is the first major case that we did it wrongly, let us start afresh, let us do proper investigations. Because really what I'm looking for is colleagues of mine who are lawyers to move to court to sue the ICC, because they have abdicated their role. Their role was purely to defend Wanjiku, to defend the victims. Have they defended the victims? They have not.
All right, Dunstan and Muthoni, just in 30 seconds then, because we're out of time, should the Bureau come out on Tuesday and not support Kenya's stand, should we pull out of the ICC altogether, as we're sort of threatening to do?
Pulling out does not help, because Article 126 and Article 124 clearly say that whether we pull out, still within 1 year, the ICC has power to proceed. Even they go further and say we will still be paying our taxes to the ICC even when we have.
So we stay.
So we have no option but to stay and fight inside.
All right.
And the ICC must listen to us. They have no option.
All right, Muthoni?
I think it'd be unfortunate if Kenya pulled out, but I really feel that Kenya has not been constructive. If it wants to pull out, if the political class wants to pull out, really that's up to them. And I think then we all go back to the drawing board. For me, my issue is there is this mass of victims, none of whom have received criminal justice, and I think we'll continue to work on that however we can.
Okay, all right. Thank you both, Dunstan Omari and Muthoni Wanyeki, for coming in and discussing this issue. We'll be getting to your feedback in just a moment. The hashtag is Checkpoint. I can see some of that coming in. Thanks for that, Vincent Oma, saying pathetic reasoning that because mass crimes are happening elsewhere, ICC should stop picking on Africa. Wycliffe says, yes, it does. That's why our politicians are restlessly lobbying against recanted evidence. Keep your views coming in. This is Checkpoint.